So surely it's not binding. Or you saying that the bench cannot pass such an order?
No. I'm saying unless, if your lordship declared the rules as ultra vires or a particular rules, of course they are not binding. But unless that is...
now we take the discussion a bit forward. If a bench of this court states that the rules under 184.3 have not been formulated in the Supreme Court Rules 1980, and therefore matters, till such rules are made, such matters should not be fixed for hearing, excluding habeas corpus matters. Can such a bench pass such an order?
If there is a constitutional basis for it...
I'm just asking you a thing, yes.
My lord...
184th at existing rules... I'm not talking of hypotheticals, I'm talking about the rules 1980 as they are. A bench of this court says, since 184.3 petitions have been filed, and the mode and manner of how they should be heard has not been determined in the rules, can a bench pass such an order?
Yes, a bench can pass such an order if the bench can show...
And can the bench then say, let the full court make such rules?
On the first part of the question, the bench can pass such an order if such a restriction can be inferred or is present in Article 184.3, that 184.3 powers cannot be exercised until rules are made. If the bench holds that rules, unless rules are made...
I'm saying if, no, I'm saying it has done it. Now, either you say it's not permissible or it's permissible.
If a constitutional basis can be shown for that, I think, of course.
Okay.
I mean, if the rules are violative of the Constitution...
There has been a case where a bench, bench of this court said that the rule should be enacted by the full court.
Yes.
Now, if even exercising judicial power can be thwarted by saying no, then how do you get the rules made? It all depends now on the person of the Chief Justice. So please explain that to me. I mean, why are we just skirting the issue, hypotheticals? Why are we not coming to actual practical things which are happening in Pakistan where cases have been decided and sort of all over the place? Just take the bull by the horns and ask.
Sir, I'll come to that. I'll just cite two judgments.
I mean, I just want to know the clarity on this issue.
मैं वो खत्म कर दूं, 1 मिनट दीजिएगा मुझे, सिर्फ 1 मिनट. There are two judgments, if your lordship, and I will not read them because I've already...
You can just add to that. Parliament can't make it. A judicial order cannot ask for these being made. So at the end of the day, it is all power vests in one individual called the Chief Justice of Pakistan, and that is
that is exactly my next point, but I'll just, because I just want to hurry. There are 3 judgments which your lordship may look at. At page 5, the first judgment, 92 SCMR 1208. This is where I draw this principle, where Justice Ajmal Mia,
12?
Sir, Afzalullah, sorry.
No, 120?
1202, where they say that we will not follow such statutory provisions, and it will not override the rules which violate the independence of the judiciary. So this is where I draw that principle. There are 2 judgments.
But this judgment says that the rules will prevail
over
the statute.
Yes, if the statute violates the independence of the judiciary. That's the criteria. But as a general principle, there are 2 judgments. One is from India, AIR 1964 Supreme Court 855. It's all written there, in which this conflict came before the Indian Supreme Court.
Where is it written in your booklet?
Page 5, top of
Sir, ये page 5 पे first 2 paragraphs देखिएगा, और अगर ऊपर ही देखिएगा तो मैंने एक judgment दी है AIR 1964 Supreme Court 855, in which a conflict between a rule of the Indian Supreme Court as well as an act came, and they said the act.
I still don't know. You're going again around. Simple proposition is no. Sorry, you have to answer these questions. So all power vests in the Chief Justice, not in the full court, because full court is then dependent on whether the Chief Justice wants to call a full court meeting or not. The last full court meeting before the one that was called on 18th of December was about 4 years before. Prior to that, a lot of issues had accumulated which have still not been addressed through the full court meeting. So why are you hesitant in calling a spade a spade.
Sir, I'll answer that question now. My lord, the proposition which has been put forward, and this is one of my objections on the Ghulam Muhyiddin case.
फिर आप केस पे चले गए।
जी, सर
आप जवाब तो दे
मैं
दीजिए।
दे रहा हूँ।
तभी आप इधर चले जाते हैं।
That is the first
नहीं,
case.
हम नहीं,
मैं जवाब दे रहा हूँ।
आपको मैंने एग्जांपल दे
मैं
दी है।
जवाब दे रहा हूँ, प्रिंसिपल स्टेट कर दूँ।
अच्छा चले, मैं आपको बता देता हूँ। अब चलें, हम इस कानून को उड़ा देते हैं, ठीक है? इस कानून को हमने उड़ा दिया, ऐसी मफरूजा दे रहा हूँ, ये कानून उड़ गया, ठीक है? अभी कोई रूल बनाना, मैं नहीं फॉल कोर्ट मीटिंग करता हूँ, आप करेंगे क्या मुझे जरा बता दीजिए। नहीं, ये देखिए फैसल साहब, you are a highly acclaimed constitutional lawyer, so praising me or anyone else should not be a substitute for responding to a query. A constitutional query I'm asking you.
अभी यही क्वेरी आपका।
आप फिर आप इस केस में ले जाएंगे गुलाम मुहय्यिद्दीन में।
अब मैं कोई केस साइट नहीं करूंगा, आपके सवाल का जवाब दे। सर, the independence of the judiciary is not linked or is not threatened if the role of the Chief Justice is reduced. Now, that is not the principle. That I think
it took you a long time to say that.
Yes. No, I've written that here, sir.
You haven't said it.
Here. So this whole debate that the master of the roster must be the Chief Justice has been elevated to a constitutional principle. It is nowhere in any case law as a constitutional principle. As Mr. Salahuddin rightly pointed out, its whole basis is in terms of judicial history and in terms of statutory law. Ghulam Muhyiddin case is the first case which lays down that the Chief Justice, being the master of the roster, is linked with the independence of the judiciary. Your Lordship will find no case which makes this link. The link has always been with the independence of the judiciary linked with the Supreme Court itself, not with the particular...
Professor Siddiqui, as far as the interpretation of judgments, what has been decided, you can give a lecture in a law school. Okay? Here the full court of Pakistan is sitting. We don't want to be given a lecture on precedents. We want to be enlightened by the understanding of the Constitution, which we keep saying is an organic thing, pulsating, evolving, catering to all sorts of situations. I mean, if you're just going to be stuck with the case law, then we should just take a lecture in some law school.
My answer is...
There is no constitutional input then coming.
My answer is that there is nothing in the Constitution...
The context of that, what you're citing from that judgment is legislative intervention. But the problem is not whether the Chief Justice is the master of the roster. That is not the context of what we are considering now. The context is, and let me therefore ask you the question which I have asked Mr. Salahuddin and Mr. Zaid Ibrahim.
I thought if we talk about which question comes first, now another question has been put on another question. Can you answer mine and we get on with it, and another question can be asked. So please don't mix up my question with other questions. You respond to my question. Let another question be asked after you've given an answer, or you can keep your answers safe till you finish your submissions.
My Lord,
I don't want my question to be added on to when I have a clear-cut question. Hopefully you've understood it. If
yes,
you haven't, I've explained it further.
Yes.
Thank you.
If I may answer.
Sir, I thought you'd finished with your answer.
No, sir. Thank you. Sir, my answer is that reduce...
Never take my permission.
Sir,
Double standard.
नहीं sir. आप मुझसे
मेरी कोई बात नहीं, लाइन पे नोट आगे बढ़े.
बड़े सवाल कम पूछ इसलिए मैं रिलैक्स्ड हूँ.
Are you taking the permission for...
चलिए आइए आगे बढ़िए.
Sir, there is nothing in the Constitution which equates the Chief Justice with the Supreme Court. And what has this law done?
So why don't you say so? End of story. What's more to be said?
Sir,
then?
what is this law? सबने
Mr. Siddiqui,
sorry.
Is this your answer?
नहीं आंसर हुआ है, बात तो कर लीजिए, बात कर लीजिए वैसे सिद्दीकी साहब. मैं सबसे आज मैंने सबसे कम सवाल पूछे. सिद्दीकी साहब मैंने आज सबसे कम सवाल पूछे. कम से कम यही राइट मास्टर ऑफ द रोस्टर को दे दीजिए प्लीज।
इसका जो कॉन्टेक्स्ट है ना वो बात का वो ये है, जो मैंने सवाल उनसे किया था अपना सलाउद्दीन साहब से, जाहिद इब्राहिम साहब से, दिस लॉ आप तो इसको बड़ा रिस्ट्रिक्टेड कर रहे हैं ना, बट व्हाट दिस लॉ डज इज इट मेक्स पार्लियामेंट द मास्टर ऑफ द रोस्टर फॉर द सुप्रीम कोर्ट ऑफ पाकिस्तान।
आप इससे फैजल साहब नहीं कर रहे
Nothing
अभी
in
तक।
this law will do.
इसको ये असर, इस सवाल का आप जवाब दीजिए।
My lord, there is
इसका
nothing in
जवाब
this.
दीजिए पहले साहब के
There
सवाल
is
का, मेरे
nothing
सवाल
in
का।
this law which makes Parliament the master. I mean, what has happened to the Chief Justice under Section 2? Has his role been eliminated? He is one of the members of the
No, no, you're
committee.
missing the point. You were present.
आप अपना जवाब तो सुन लेना आपका पहले, आप जवाब दीजिए प्लीज।
Sir, in terms, because there is no constitutional provision which gives this elated position to the Chief Justice, and the Chief Justice is equated with the Supreme Court. For example, giving the power of the constitution of benches to three senior most judges, how does that violate the independence of the judge?
I'll tell you.
How
ये
does
आप
that
बात तो
violate?
कंप्लीट कर लें प्लीज।
Because it is that committee is the creation not of the full court, but or the
मैंने आपसे दो
confirmation
तीन
of-
बातें और भी पूछी थी। अगर चीफ
That
जस्टिस फुल कोर्ट ना कॉल करे, अगर चीफ जस्टिस कुछ ना करे, तो फिर पार्लियामेंट ने कर लिया एक काम, ठीक है, मुझे करना चाहिए था, नहीं किया मैंने, तो किसी दूसरे ने कर दिया, तो अब वो कॉम्पिटेंस है, तो अगर मेरे ही में कॉम्पिटेंस है, चलिए वो बात भी मान लेते हैं, नहीं है तो फिर इसका मतलब एक लॉक जैम हो गया, क्योंकि चीफ जस्टिस ने कहा मैंने तो करना नहीं है किसी सूरत में, और मैं किसी और को भी नहीं करने दूंगा। तो बुनियादी बात तो यहीं आके ठहरती है ना। अब सादी बातों को सादे अल्फाज में बयान करते हैं ना, इतने जजमेंट्स, ये पहले इशू आया नहीं था सुप्रीम कोर्ट के पास, तो नया इशू है, तो आप ज्यादा आइन को मद्देनजर रखते हुए उसकी तशरीह कीजिए ना। अगर हम आइन की तशरीह सिर्फ जजमेंट से करने बैठे तो फिर हमें टेक्स्ट बुक उठा लेंगे, पढ़ लेंगे, उसमें वकीलों की जरूरत नहीं है, उसके कॉन्स्टिट्यूशनल लॉयर्स की भी जरूरत नहीं होगी। आप कहिएगा फलां आप पढ़ लीजिए बुक ऑन कॉन्स्टिट्यूशनल लॉ, आपको सारे जवाब मिल जाएंगे, नहीं, वहाँ जवाब नहीं मिलेंगे, क्योंकि अब जो चीज़ें हम अब देख रहे हैं वो पहले नहीं देखी गई थी, और हो सकता है पहले गलत देखी गई हो, ये भी मुमकिन है। तो अपना विजन खुला रखना चाहिए, बेशक वो मेरे खिलाफ बात हो या मेरे फेवर में हो। इधर तो मैं अपने फायदे की बात नहीं कर रहा हूँ, जो आपको इसमें कोई रुकावट होना चाहिए कि आप चीफ जस्टिस के सामने खड़े हों और चीफ जस्टिस कह रहे हैं कि आप मेरे इख्तियारात में कमी ला रहे हो, तो आप हिचकिचाहट क्यों, आपकी तरफ से क्यों
मैं
ये
कोई
हिचकिचाहट
हिचकिचाहट
है?
नहीं, मैंने तो क्लियरली स्टेट